Welcome to the McNeill Family Law Podcast with Burl McNeill. Burl McNeill is a Calgary family law attorney whose practice is focused on helping clients to navigate the difficult decisions that must be made in a divorce. Today, we're talking with Burl about her background and what has led her to practicing family law. So, Burl, just to begin, who are you?
Well, I'm a Calgary family lawyer, as you indicated. I've been practicing for 31 years, and I started practicing collaborative practice at the very beginning. I'm an early adopter of collaborative family law, and really have taken it on in terms of it being a better way for families to navigate their separation and divorce. So early on, when I practiced, I first was called to the bar in Vancouver, British Columbia, and I practiced there for 5 years. And that was also my first experience with some of the traditional family court system. And the traditional family court system, very soon I was exposed to in terms of a standard traditional adversarial court system where people are waiting for their court applications. We're putting families in a situation where they're in an attack defend model, written affidavits, what mom says about dad and dad says about mom. And it didn't take very long for me to say, wow, this is really not healthy for families, and I really don't want to be a part of that. However, when you're a junior family lawyer, you have to do what the law firm, has you do, and you're getting your wings, getting your experience. So I did it, and I also did other litigation work, and actually focused on a lot of other litigation work because I thought, well, if I'm going to be in the court system, I'm happy to be a litigator, but not when it comes to applying a litigation model to families, which is clearly not the best model for families to navigate their separation and divorce.
So, for somebody who chooses this process, what does it look like at the other end of the divorce after it's over for them versus if they went through that litigated adversarial process?
At the end of the day, if you have property, which most people do in Alberta, you're going to have a legal separation agreement that is enforceable, that addresses everything. It addresses your child support, spousal support, how you're going to divide your finances, what your parenting plan is, and it's going to be an all-encompassing agreement. So you'll have certainty and finality regarding your separation and divorce. Whereas in the court system set up so that someone else will make your decisions for you. And there's many decisions to be made. Decisions around, a lot of people refer to it as child custody. In Canada, we no longer call it child custody, we call it parenting time. So what's your parenting time? How are you going to divide your assets? What's your child support going to be? And what's your spousal support going to be? So most people, that's a very expensive system for you to retain a lawyer and take you through that. And most people are going to try to reach agreement and narrow the issues and reach agreement on the items they want. And indeed, our court wants you to do that. There's mandatory dispute resolution. They want you to find other ways, to figure out a way to negotiate your separation agreement. And if you're unable to, then other people will make your decisions for you. And it takes more time and more money.
For children, are children healthier afterwards when this process has been used in terms of their relationships with their parents and how their parents parent?
With collaborative law, we're way more exposed to the social science related to how divorces can be damaging. And I was actually surprised that when the psychologist said, well, divorce is an adverse childhood experience. So adverse childhood experiences, you want to minimize those for your children. I think it's if you have 4 or more adverse childhood experiences, there is solid science that says your child's going to be more susceptible to mental health illness, even physical illness and addiction. And you can actually, Google adverse childhood experience, and you can see the more adverse childhood experiences, I think sort of 4, it starts at 4 or more, puts your child at risk. Another thing that the child specialists and psychologists have identified is some stress for your child. It's natural, you learn to adapt, but it's ongoing stress, the adrenaline and cortisol that's impacting your child's brain, right? So the ongoing adrenaline, cortisol, ongoing stress, which an adversarial, when mom and dad are fighting in an adversarial court system, they're more likely going to be subject to this, they call it toxic stress. And that's damaging. I always say the rules of court were never designed for families. The rules of court was designed so, to whenever the evolution of the courts evolved, King Henry VIII is like, basically, the divorce was in the function of the church, and then King Henry VIII said, well, okay, I want a divorce, you're not giving me it, so I'm going to take it into my purview, and then it goes into a court system. That's a dispute resolution system he had, but really that's for, figuring out resolving debts and having to have someone, a third party judge, a lawyer in the court and a judge making a decision regarding your dispute on the king's land. So that model, attack, defend, okay for commercial disputes or in criminal law, but it was not designed for families, right? So we're in a different era. We're in a different era of divorce. Then how can we design a system that really supports the family and de-escalates the conflict and educates parents? Because no parent going through a divorce wants to damage their children. So let's get that information to the parents. And let's put them not in an attack defend model. Let's put them in a model of, okay, it's a dispute resolution model regarding, okay, what's important to you? What's the information we need to know, both legal and also about your family? What are your objectives? And so the lawyers are trained in interest-based negotiation, really like mediators, co-mediators. And everybody on the team, if there's a child specialist involved or divorce coaches, everybody is working to the end goal to meet the family objectives in the healthiest way possible. The system, the model is really set up in the best way to support each individual family. And it isn't a one size fits all, even within the model, right? So what's fundamental is that the lawyers that are helping you negotiate this agreement are never going to be cross-examining you in court. They're never going to be, 1 minute we were in a settlement meeting, and then I saw in that settlement meeting, boy, that person would be terrible in court, to be a terrible witness. And then I know how to cross-examine that person in court, right? So the whole critical part of collaborative practice is that disqualification clause in terms of, if we don't reach an agreement, you have to then hire litigation lawyers to resolve whatever usually if there was certain issues that aren't resolved, then you use different lawyers to do that in court.
So if somebody's now saying, okay, well, now this is the direction I want to go, where do they start? How do you start down this road?
There is a lot of information online. The International Academy of Collaborative Divorce has, so that's an international organization that has all kinds of information on their website. And I believe that is collaborativepractice.com. I have information, of course, on my website to educate and empower people on divorce process options, and specifically in Calgary, Alberta, where I am at. So I have a bunch of information on my website. We also have in Alberta, Collaborative Divorce Alberta Association, and that has a website, which is collaborativepractice.ca for Canada. So that's a good start. What I love about telling people about this, and what I've loved about the growth of this organization, it started in the United States, but quickly spread, and I can't remember how many different countries it has spread to. I think it's 28. Isn't that interesting? There's all these different countries with different laws. The family law in Italy is different than the family law in Israel, right? And all of these people are saying, this is the way to do this. And so, yes, the law is different, but fundamentally it's a non-adversarial practice model designed for the families that are going through the separation divorce. So everybody's doing their job. This is more than just the law that I learned in law school. There's a social science element that we need to be aware of, et cetera. And we need to work as a team to help this family navigate through this difficult time.
So if someone specifically wants to reach out to you, how can they get a hold of you?
They can go to my website, and that is McNeillFamilyLaw.ca. You'll see more information there, and you'll see a contact form if you want a consult, and phone number, and that's the best way to get started.
Okay, well, this has been the McNeill Family Law Podcast. If you have questions that you would like to talk to Burl about, you can contact her at 587-956-9300 or through her website at McNeillFamilyLaw.ca. Burl, a fascinating conversation, and we'll look forward to doing it again.